The speed racer icon.
Nope, it's me. I was just letting everyone in the meeting. I think we have everyone, and we are live streaming on YouTube for your fan base that is watching all this. So let me figure out if we've got all the right folks. This is an interpleader, Sheriff Jackson versus Atlanta Asset Recovery and a whole bunch of other people. I'm gonna wanna figure out who all is on the call, and I'm just going in the order people are appearing on the screen. So the first one is Alex Dishon.
Good morning, Your Honor. This is Alex Dishon for FIG Georgia 13 LLC.
All right, FIG. And there's me, there's Mr. Clark. Good morning, well, afternoon, good afternoon, Mr. Clark. You have Atlanta Asset Recovery.
Yes, Your Honor, and Tara Porterfield from my office is also on the call.
Okay. Two people managing Atlanta Asset Recovery. All right. Mr. Harkins.
Yes, sir. Here representing the sheriff petitioner.
He wants his money. Mr. Sams, you here for Investa?
Yes, Your Honor.
Okay. Mr. Oram.
Yes, Your Honor, I'm here for Pathfinder Financial.
All right, they have a judgment. Pathfinder. Mr. Siegelman.
Yes, Your Honor, Joe Siegelman here for the City of Atlanta.
All right. And then Ms. Wyatt Bowman.
Yes, Your Honor. I'm here with the City of Atlanta as well, but my colleague, Mr. Siegelman, is going to handle this.
Great. Then I won't bother you again. Thanks for dialing in. You can remain anonymous like that. Mr. Gao, my summer intern from Emory, is listening in, so please be professional for him so he can see lawyers at their finest. And then my staff attorney, Ms. Niles, is on as well. So here's the little I know about this case, and then I think I'll start with Mr. Harkins, and then if you guys have already worked this out, someone can just raise their hand. But let me first tell you what I know about the case. So we have about 25,000 in excess funds. The sheriff is claiming about 4,000, a little bit more, which leaves a corpus of a little less than 21,000 that we need to figure out where it goes. There are a series of competing claims. Mr. Clark and Ms. Porterfield say it goes to Atlanta Asset Recovery, and I've got some exhibits that we can work through. Apparently someone sold for about $1,300 to Atlanta Asset the rights to pursue some of this. The city has a whole bunch of bills that would swamp the amount that is in the registry. Pathfinder, I think the judgment is pretty small. The notation I have here is that Mr. Oram, you're seeking all of the funds, but I think you could be satisfied with a whole lot less than that. And we'll work through that. We don't have to sort that out right now. FIG has some, the solid waste assessments they bought, and looks like Investa bought a year's worth of ad valorem and maybe sanitation fees. Both those are amounts much smaller than the amount that is in the registry of the court. So that's where we're coming from. Mr. Harkins, why don't you tell me what the sheriff wants, and then you may be done with the role you need to play in this.
You actually did my job for me. You just kind of ran through the various claimants. This was from an October 2018 tax sale. The property was sold out of the name of Martha Johnson Estate in Practo Gamble. Apparently, Miss Johnson and Mr. Gamble were married and owned the property as tenants in common. And so there's an affidavit of descent that I think John Clark has put into evidence that is, there is one heir, there is one child of that union. That is the way that his client got title of the property. So John has kind of been this in the stance as the owner of the property at the time of the sale. So
Okay.
the sheriff, I was going to go list through those, kind of list through the claims. I will say the sheriff's motion for costs was filed in February. That total is $4,293, of which $1,153 is for costs, filing fees, service fees, all that. And then attorney's fees is $3,140. Again, the total is $4,293. The specific amount of excess funds is $25,124.28, 25,124.28. And those funds are in the court registry. They are currently with the clerk's office.
Okay.
So Atlanta Asset has made a claim for all of the funds as the owner of the time. The estate of Martha Johnson filed an answer and statement of no interest. The administrator filed that, so there's no claim from them. As you said, City of Atlanta has claims in 3 classes. One is for taxes, which I think Mr. Siegelman will talk about. I think those have been paid maybe. The second set is for the water sewer, which is $16,000, almost $100. And then another $13,000 for a demolition lien. But I believe we established that the demolition lien was set after, accrued after the tax sale, so that would not be applicable. But again, I'll defer to Mr. Siegelman on that. Georgia Department of Revenue did not file anything. They were served, so they're in default. Pathfinder, again, as you mentioned, their interest is based on a judgment lien. I think and I'll defer to Mr. Orm here, but I believe the total number that they're looking for is $7,296, which is based on the statutory interest that's accrued since it was originally put in place. FIG is asking for, again, I'll defer to them on the numbers, but $1,347.26 for solid waste for 2017 and 18, which is the original lien amounts plus interest. Any and all parties, they were served by publication. Nobody came forward with them, so there's no claim there. And of course, GS Renzi successfully intervened, and they're asking for a grand total of $551.06. So those are the different claims, and I'll just let everybody else jump in now.
Okay. Well, Mr. Clark or Ms. Porterfield, why don't you start as the purported owners of the property? I've looked at the affidavit of dissent where Ms. Browder indicates that she was Procter Gamble's child. And then the second exhibit you provided was the quitclaim where Ms. Browder sold to your client for $1,350 the parcel that is at issue here, although it looks like that was in June of 2019. So timeline wise, that's, I guess, after the tax sale. So walk me through where you think your client's claims are vis-a-vis some of the other folks we've got on the phone, and then I'll hear from them as well.
Sure, Judge. I don't think there's any dispute that my client is standing in the steps of the homeowner. And so if the homeowner, Procter Gamble and his wife, Martha Johnson, were they to have received anything, then that would just flow to my client. I don't think there's any dispute there. The question is, would the homeowner be entitled to any excess tax sale money in this case? We certainly don't claim all of it. All we're claiming is whatever's left after all the valid liens are paid, and I'll walk through that in 1 second. Certainly, we have no objection to Mr. Harkin's legal fees. We have no objection to the FIG liens. We have no objection to the Vesta liens. I mean, the tax liens certainly take priority along with Mr. Harkin's attorney's fees. I don't anticipate having any, or I don't assert any claim against Pathfinder or dispute on the Pathfinder liens. The real question is the City of Atlanta's claims. If their claims succeed, then I believe they probably take ahead, well, they certainly take ahead of me and probably against Pathfinder. If their claims are not upheld, then I think there's enough to go around to pay Pathfinder and my clients would inherit the rest.
Okay.
So I'll very quickly address the city's claims and then I'll let them say whatever they want to. I mean, you tell me, but I just let them to say what they want to about their own claims, and I'd like to be able to respond to what they say.
Sure. Why don't we do that? I'm hearing you, Mr. Clark, say that you've got no objection to FIG, Investa, Pathfinder, or of course the fees that Mr. Harkins is seeking to collect on behalf of the sheriff and then the legal representation. And I'll certainly hear from each of those folks whose claims you're not objecting to, but I think it would be productive, most productive, to start with Mr. Siegelman, because Mr. Harkins represented or suggested that maybe a few of the claims the city originally set forth may have fallen by the wayside. Mr. Harkins described three categories. There was the unpaid taxes, there's the water sewer, which is a big number, and then this demolition lien. Are any of those categories now off the table, Mr. Siegelman, or is everything on the table and we need to wade through each one?
Well, yes, Your Honor, and thank you. So you're absolutely correct. There are three general categories. There are the taxes, the water bill, and the demolition lien, all of which the city asserted in its answer. Since that time, we have learned that the taxes owed have been paid based on our records. So we are not pursuing taxes today, which leaves the water bill and the demolition lien. And I'll actually skip ahead to the demolition lien because that was another that Mr. Harkin mentioned. The city maintains its claim for the demolition lien, although we did discover that the date that the lien arose, the origination, as well as the date it was perfected, came after the tax sale date. The Liz Pendes was filed in July of 2018 before this action, and the city believes that that would still be a valid claim, even though the date that the lien was perfected came after the tax sale. With regard to the water bill, all of those charges accrued against Mr. Gamble. The bill that the city has as an exhibit today shows the date of July 2018 before the tax sale date, and the city believes that all of those water bills are valid claims and due to be recovered from the excess funds.
What is the amount of the demolition lien? I'm looking at your three exhibits, and one of them is a tax bill. It sounds like we don't need to worry about that anymore. One of them is the water bill. I know what those look like. Mine is a little smaller, fortunately. And then there's just this letter. Is that the demolition lien? And where would I find, is that it's 11,512?
Yes, Your Honor. So the demolition lien originally was I'm pulling it up to ensure that I tell you this correctly. Yes, the principal balance, the bill originally for the demolition was $11,000, roughly $500. And since that time, again, this was October of 2018, there's been a penalty that's accrued of $1,700, bringing the total amount to $13,200 and some change as of February 29th of this year.
So just so I haven't had one of these cases with a demolition lien. Does that mean that at some point the city came in with court authority and basically tore down the house because it had fallen into disrepair and was deemed to be either a nuisance or a hazard or both?
So, Your Honor, I wish that I could accurately answer that question. I don't know the specifics underlying the reason for the demolition. As I understand, the demolition itself wasn't challenged, and that everything that occurred leading to the demolition was done appropriately as it should have been, and that the lien is subject to recovery. I don't believe I can answer the specifics as to what led the demolition to take place in the first place.
So I may be putting you out on a limb again, and I appreciate you only answering what you can. The paperwork you submitted, the orders, the results of the public hearing, actually what's checked by the board members is clean and close. And the notices that were being provided to the owner or occupant, and it lists Mr. Gamble and his wife, Miss Johnson, as the defendants in this. It lets them know that it's going to be either the cleaning and closing or the demolition. Then there's a bill attached. So it sounds like the cost was not for knocking it down, but for cleaning the lot up and effectively sealing the house, boarding up the windows and doors, et cetera. I don't think that changes anything. We call it a demolition lien. That makes me think the giant bowling ball type thing swinging into the building and knocking it down. But it sounds like here they literally cleaned the yard up, maybe removed stuff in the yard and boarded it up. But either way, it cost the city a bunch of money. It was authorized by way of public hearing, et cetera. And your point, Mr. Siegelman, is the lis pendens was filed or obtained before the tax sale, and that gets the city's foot in the door for the $11,500. The money was spent, and all that work was done on the lot to make it less of a nuisance or hazard or both, and the city's now trying to collect that. Is that a fair summary?
Yes, Your Honor, exactly.
Okay. All right. So, Mr. Clark, tell me from your client's perspective why either the water bill, or we'll keep calling it the demolition lien, the clean and close lien, why those don't go to the front of the line, or at least consume whatever would be left if we paid off some of these other obligations, the tax bills, et cetera, which would not consume what is left.
Well, the demolition lien wasn't made of record until after the tax sale. And I think under the Court of Appeals decision in DLT List versus M7, which is sort of that's a 2015 case that dramatically changed how excess funds was distributed. But at least in that case, they answered the question of at what point do you measure the priority of the claims, and they settled on the tax sale date. That case did go to the Georgia Supreme Court on cert, but they didn't address or change that aspect of the Court of Appeals decision. So I think that's still the date. And the only reason I heard as to why a lien that is not a lien until it's recorded in the record would apply to this funds when this tax sale happened before the lien happened was because of a lis pendens. Well, a lis pendens notice is merely a notice to all the world that a lawsuit has been filed concerning the title to the property of the subject property. There is certainly no evidence, and I don't think a case ever being filed where title was at issue by the city, or any case at all where a demolition or clean and close was ordered by a court. All we have is a bunch of unsubstantiated letters and invoices from contractors that aren't here to testify as to what they did. Were they reasonable in what they did? Were they following a direction of an administrative body, a court, whatever? Did they exceed that? I mean, if you look at what was circulated, there's like $9,000 for cutting the grass of a vacant lot, which I'd like a little bit more information about, but I don't have it here. I don't have any witnesses telling me what they did, when they did, under what authority they did do it. So under the clean and close, that would be my argument. And twofold, is untimely if you accept the dates that are submitted to us. And two, it's all hearsay. We don't have anybody to authenticate any of this stuff. That's my argument on the clean and close. The water bills are a little different, although not much different. $16,000 for water bills. The bill that they have circulated certainly has not been authenticated by Watershed as part of a business record or give me any reason to that I've seen to have it admitted. I certainly would be very interested to know over what period of time these liens were incurred. Water bills do not last in perpetuity. There's a Georgia Supreme Court case on that. I can give you the citation here as I scroll down. It's Brown versus Walton Electric Membership Corporation. That's 272 Georgia 453. And they specifically, the Supreme Court of Georgia specifically says statutes of limitations are a defense to water bills.
What is the statute of limitations for water bills?
It is 4 years under an open account. Unless Watershed has you sign a written agreement, it'd be 6 years under a contract. But like your utility, when you sign up with your cable bill or your gas bill or whatever, it's an open account under OCGA 9-3-25. There's a 4-year statute of limitations on that. But what I don't know is at what point in time did the bulk of this $16,000 get assessed?
So if the tax sale was in October of 2018, your read of Brown versus Walton would be that the city has the ability to pursue the bills from October 2014 through October 2018, but something from 2013, it's frankly too old, again, unless there was some special agreement that someone had signed that would extend the statute of limitations.
That is my understanding, yes, Your Honor.
Okay. So Mr. Siegelman, are you in a position, if not now, sometime in the very near future, to provide a more detailed water bill that would show what amounts were accrued each year? Or does the system simply say, here's the total amount?
So I want to make a couple points, Your Honor. First, to answer your question directly, yes, I do believe there is a way to see what amount was charged when and how the water bill has accrued over the years to the amount that we see today. I do believe that's something that I can obtain. With regard to authenticity generally, I do have a certified copy of the same water bill with me today that I can present to the court if you want to see it. I do not have a breakdown of the bill based on when certain charges were made. I will tell Your Honor that I am not familiar with the statute of limitations asserted, this 4-year statute of limitations, without looking at the case myself and making an assessment. I'm not prepared to concede that the city would only be able to recover from October 2014 up to the tax sale date. As I understand, there is not a statute of limitations on an open water bill with a particular owner, that if the charges were against a particular owner of a property for water, that that amount is due to be paid and is recoverable by the city. Again, that is my understanding.
Okay. And what is your response to Mr. Clark's observation that the lien wasn't filed? Well, that appears to be fact. I was looking at your exhibit, and the lien for the demolition lien wasn't filed until December 2018. So it's 2 months after the tax sale. Is that a distinction without a difference? The lis pendens is sufficient, and that was a placeholder to let everyone know, or per the M7 case, liens are what matter. And so what we look at is October 2018, what liens, not lis pendens or wishes or dreams, but liens were in place against that piece of property when the tax sale occurred. And if that's the right measure, that there has to be a lien, then unfortunately for the city, doesn't mean they'll never collect, they just are further back in line. It was not a lien that was in place because the tax sale snuck up on them and occurred 2 months before the lien was perfected. So I'm setting aside whether they were not paying what I pay my kids to mow my lawn. They were paying, like, it was must have been a gold lawnmower or something. But setting that aside, how do you reconcile lien versus lis pendens?
Well, obviously, Your Honor, I can't speak to the specific work done, how it was done, or how extravagant the lawnmower. But I do understand and do not dispute the date in the city's own record regarding the lien date. I am aware that the liens at issue are those that came about before the tax sale. The city presents that claim and presents the exhibit of the demolition or clean and close lien to preserve its right to recover that amount with the understanding that that it did occur or that the lien was in fact perfected after the tax sale date.
Okay. I appreciate that. So, Mr. Clark, as the party hoping there's something left when the dust settles, what is your position as to the way in which the other claimants are prioritized? If we set aside the city, I'm going to give Mr. Siegelman some time. I don't mean right now on the call, but some number of days to do a couple things for me. But how would you prioritize the other claimants in this case?
Tell you exactly. Well, the attorney's fees probably come first, I would guess, for Mr. Harkins. That's sort of a question I don't really know, but probably first. Then it goes, you start at the state level if there are state liens, and you go oldest to newest first in priority.
And there's no such thing as an expiration. Is there a statute of limitations on the lien? If the lien was from 1840, that's going to be the oldest?
No, Your Honor. I forget the tax liens have a 7-year statute of limitations.
Okay,
That's
but nothing here is that old. Well, the judgment's pretty old, but that's different. We'll get there.
Right. So the tax liens have 7 years, and I know Mr. Sams can recite that statute. I think it's 48-256. Maybe wrong. And then, but they go state oldest to newest, then drop down to county oldest to newest, and then the city oldest to newest property tax liens is how that's paid out.
Okay.
And then we would have usually the judgment lien oldest in time, and this one goes back some period of time. They have 7 years, but they can renew their claim by re-recording their lien or getting a nulla bona of their lien. I believe that was done within the first 7-year period, gives them another 7 years. So then Pathfinder would be paid their money, and then my client would be would take what's left with the asterisk of if the city's water bills, I believe, have a heightened priority, almost to the level of taxes, but not quite. They don't trump taxes, but they would probably beat most of anything else if they're enforceable, subject to the statute of limitations. And then their demo lien, that would be paid last.
Okay.
That would be paid in lowest priority, and then my clients would take. Yeah, I think Pathfinder falls somewhere in the middle between water lien. If the water liens, then Pathfinder, then the demo, just based on priority of time.
Okay. Well, let me ask a question of Mr. Oram. I don't see, you filed one exhibit, which is the judgment. Where would I find on the judgment that you renewed that? Because the judgment is from 2004, and that wouldn't still be kicking well, actually the judgment December 2003 is when it was received. It may not have been recorded right away, but either way, it's expired unless you did the magic things. How is that judgment still kicking?
Yes, Your Honor. The judgment was properly renewed since its issuance, and you'll see on the writ of 5A that was sent to the court for the Pathfinder's exhibit. You'll see the different stamps located throughout that show the dates along the timeline in which it was renewed.
So it's not an area of law in which I frequently practice, but my head is sideways because I'm trying to read. There's stamps all over this. So that's all it takes. I see here Kathleen Robinson, and it looks like in June of 2016, there's another stamp on this. So that is evidence that it was renewed?
Yes, Your Honor.
That's how they demonstrate that it was renewed. They just put another stamp on it with a more current date.
Yes, Your Honor. It's submitted to the county for renewal once every 7 years. And so long as the county recognizes that it's been properly renewed, it'll be stamped and it will continue to live on for another 7 years.
All right. Well, with that renewal in 2016, you're good through 2023. So the ship has arrived. Do you agree with Mr. Clark that you are in line behind tax liens and if there's going to be a water bill, the water bill?
Yes, Your Honor. I believe there is support for that position as far as the heightened superiority for the water bill, but I don't disagree with Mr. Clark's assessment as far as statute of limitations applying.
Okay. And do you have any objection, Mr. Oram, to the sheriff getting his fees, both attorney's fees and the cost of processing the tax sale?
No, Your Honor.
Okay. Well, Ms. Dishun, let's go to you. Doesn't sound like anyone is objecting. Although yours, are they taxes or is it solid waste assessments that FIG owns?
These are solid waste fees that were recorded as 5A.
And where does that fall in Mr. Clark's hire? I didn't hear him say anything about solid. He talked about water. He talked about tax. Is this deemed to be a tax or?
That is our position. They're deemed to be taxes.
Okay. Mr. Clark, do you agree if it's solid waste, that's good enough for taxes?
That's how it's always been treated, and no one has ever taken it up to get a final decision. So yeah, that's how we treat them.
Well, I'm counting on you or Mr. Sams to make some good case law someday about whether taxes and solid waste should be kept in the same category. I think a lot of people would agree, but it'd be good to have a court of appeals weighing in. I think.
But let's not do that here, Your Honor.
No. Let's not. These dollar amounts aren't big enough.
No.
No. Okay. So your client is sitting pretty on this, and then Mr. Sams, I think the same. Yours are for taxes and sanitation fees. So if we pretend that sanitation is sort of masquerading as taxes, you're at the front of the line as well. Do you agree?
I actually believe it's simpler than that, Your Honor. It's just ad valorem taxes.
Oh, okay.
Sanitation.
No sanitation fees. Good, because it would have overlapped with FIG. FIG seems to have 2017. I didn't know how you guys both had it, but all right, so yours is pure and simple taxes. You may be after the sheriff first in line, but you want so little, there'll be some left over. Then Ms. Dishun, your client would be next. I don't mean to leave anyone out. Where does the rest of my cheat sheet go? Okay. So, Mr. Sams, any objection to the reasonableness of the sheriff's request?
No, Your Honor.
And same question for you, Ms. Dishun.
No, Your Honor.
Okay. What I'd like to do then is give Mr. Siegelman a project, and that is to get me a certified copy of an itemized bill from Watershed. It can go back as far as the system will go, but it's a two-part project. I also want you to respond, and I'm not asking you to write a brief or anything like that. You can via email to Ms. Niles, and then obviously all the parties here include, I'm okay right now with a PDF of a certified copy, If that's going to give someone heartburn, we'll figure out a way to get the hard copy of the certified copy of an itemized bill. But then also, if in that email you could include whether it's a case citation or it's your 2 cents as to why Brown does not stand for the proposition that Mr. Clark says it stands for. And this will be the one time I need to learn that. And then going forward, in fact, I think we have another interpleader later this week. I'll know how far back water bills can go and still be in the queue for trying to recover some of the excess funds. And then my proposal is, and I'll go through each of you to say, yeah, that's fine, Judge, or no, we don't like it, is that I'll give Mr. Siegelman a few days to do that. And he can tell me in a minute how much time he needs, reasonable amount of time. Then I would enter an order that would take care of Mr. Harkin's client, take care of Mr. Sams's client, take care of Ms. DeShun's client, and then the big variable is what comes of what Mr. Siegelman sends our way. And if he is convincing and compelling, that may be it for poor Pathfinder that studiously renews its judgment every so often, and it would leave only the property for Mr. Clark's client. But I do want to give Mr. Siegelman that opportunity, and certainly Mr. Clark and Mr. Oram, I would give both of you a chance to respond to Mr. Siegelman's email if he says, you know, I read Brown, I don't like Brown. It doesn't mean that Brown doesn't stand for that proposition. So he might present a case that you think you can distinguish. I don't mean for us to go through a bunch of iterations of this. But it's helpful for me to understand how this works. And as I mentioned, this isn't an area that I poke my nose into all that often. And I want to get it right. And this will recur. So it'd be good to get it right this time. The next time you guys can have quicker conferences with me. So how does that game plan sound to you, Mr. Harkins?
Totally fine with me, Your Honor.
All right. You're getting what you want anyway. Mr. Sams?
Sounds fine to me, Your Honor.
Ms. DeShun?
That's acceptable. Thank you.
Okay. I'm going here in these orders of priority. So Mr. Siegelman, how much time do you need to try to pry an itemized bill out of Watershed?
Your Honor, well, thank you for giving us the opportunity to do that. And I wish that I could answer all your questions today. You may have noticed that I substituted for a colleague middle of last week. So I look forward to learning a definitive answer to this question as well. With regard to an itemized bill, certified records, certified itemized bill, I honestly don't know. City Hall is closed currently and still. And as I understand, certain employees aren't allowed back in City Hall at all. Some offices may send one person once a week. So I would need, I think I would need at least a week and potentially 2 weeks if that's fine with Your Honor and everyone else, just to ensure that I could get it from the right person and I wouldn't have to go back.
Well, the good news is the money's not going anywhere. And depending on how long you need, I might end up cutting 2 orders, the first of which would get money to Mr. Sams's client, Ms. DeShun's client, and to Mr. Harkins's client. They're getting it anyway. And then the remainder would sit tight. That said, this isn't going to be an infinite exercise.
That's right.
This is not the first interpleader actually, the other one I had, it was a quiet title, but the city, I'm not faulting anyone. I think this is just what you're handed. But the city's lawyer said, here's the water bill, $1 billion, but it wasn't itemized. And of course, the other side said, that's crazy. And by the way, we've only had the property for this window of time. And it struck me that the city would just normally, it would just be the standard practice. Here's the itemized bill rather than this giant number with no detail. And that may be feedback you want to provide your colleagues. But the itemized bill is what I find the other litigants understandably asking for in the end. $16,000 is a big number. It swallows all these other numbers. And where did it come from? And if there was a terrible water leak on the property 10 years ago, that's bad news. But if in fact there's a statute of limitations, that's really nobody's problem anymore, except mine as a ratepayer, as the city needs to make it back and it causes my rates to go up. So why don't you ask around, and as quickly as you can, let Ms. Niles and this crew of attorneys know, here's how long I need to get that itemized bill.
Okay.
And that'll give me a chance to react to say, you know what, it just 2 months isn't going to work. We need to get closure for everyone here. But hopefully that's not the answer. But I appreciate what you're running up against, that the offices aren't wide open. My thought would be this would all be sort of computer accessible, and at a minimum, we'd be able to get what those numbers are. And if we see there is a statute of limitations and the numbers for the 4 years leading up to the tax sale are kind of small, then we'd know actually it's probably going to be something for everyone in this. But let us know when you think you can get those figures, and provide, having had a chance to think about it a little bit, a response about the statute of limitations for the open water bills.
Yes, Your Honor. Real quick, like I said earlier, I do have certified copies of the demolition lien documents, the clean and close document, and I understand that the itemized bill is what the court would like to see. I do have a certified copy of the one-page water bill. To the extent that's helpful to the court, I can go ahead and submit that in some manner today, or if the court prefers, I can just provide what you're requesting at a later time.
So I'd hold on to those. I appreciate your candor on the demolition lien and list pendants. So I think you can hold on to that. It may be that after you talk with the folks at Watershed Data Management, the best you're going to be able to do is that certified copy of the bill you've got in your hands. And then that's what you'll provide. Then I'll have to work through a solution with that non-granular figure. And I'll do that if that's how it plays out. So I'd hold on to those things for now, and we'll figure out what to do after you have a better sense of when you're going to get your information.
Yes, sir.
I think that is everyone except now Mr. Clark. Are you okay with this game plan? I know it doesn't mean we're wrapping up today, but like I said, I'd rather get this right than wrong.
I am okay with it. Yes, Your Honor.
Okay. Then that's what we'll do. And I'll have Ms. Niles let everyone know if I'm going to end up doing 2 orders instead of 1. It's cleaner to do 1, but not at all unprecedented to have one that says, here, Sheriff, get your money, and the rest of the money stays in the registry. It could be it's Sheriff and Investa and FIG that gets money, and then the rest stays in the registry. I think that's it. Mr. Clark, anything else for AAR?
No, Your Honor, that's all for us.
All right. Ms. Porterfield, how are you doing?
Good. Thank you for asking, Judge.
Good to see you. Mr. Harkins, anything else for our sheriff?
No, Your Honor. I would ask, I have kind of a standard order. Would Ms. Niles be interested in that, just to kind of help her out, or it would be
We always like standard orders in Word format.
Okay. The
So if
numbers
you
will be
send that
plugged
to
in
her,
and
that will
stuff.
bring joy to her day.
Okay.
Mr. Sams, anything else for Investa?
No, Your Honor.
All right. Mr. Oram?
Nothing further, Your Honor.
All right. Good to meet you. Sorry we didn't get closure for your client today, but don't give up hope.
Thank you, Your Honor.
Mr. Siegelman, are you new to the city's law department, or you're simply new to this matter as of a week?
How could you tell, Judge? No, I'm relatively new to the city. I've been with the city for about 8 months, closer to 10 months. I'm not new to litigation. I am new to these quiet title interpleader actions. It's not something that I would regularly tend to, and have been trying my best to catch up since I entered this action. I apologize again that I didn't have more answers for Your Honor today.
It's okay. It's a strange and twisted corner of the law, so you'll learn it eventually. But you can see by these folks who occupies this area, very dangerous. Ms. DeShawn, anything else for your client?
No, Your Honor.
All right. Well, thank you, everyone. Appreciate your time. I will look to hear from you, Mr. Siegelman, and we'll make a plan from there.
Yes, Your Honor. Thank you.
Bye-bye.
Thank you.
Bye, thank you.